Magandang araw po muli mga kapitek at nandito na naman po tayo sa isang video ng ating NQESH review and particularly ang pag-uusapan natin ngayong video na to ay ang session number 5 po natin, Revised Rules of Procedure of the Department of Education in Administrative Cases na nakabase sa ating DepEd Order number 49 series of 2006. Umpisahan po natin ang ating video sa ating mga check your understanding questions. Question number 1. Parent came to the principal's office complaining about teacher C allegedly slapped her child during class hours. What should be properly done by the school head? Activating the grievance committee, bringing the matter to the barangay, filing a report to the nearest police station, or forwarding the complaint to the regional director. Ang tanong po na ito mga kapitek ay naka-anchor sa ating tinatawag natin na somehow yung jurisdiction ng ating mga kaso sa DepEd. In this case, tandaan po natin mga kapitek na ang jurisdiction ng mga administrative complaint ay dapat within the DepEd boundary lamang. Okay? Nasa DepEd boundary lang, hindi ito sinisettle somewhere else. Kasi kapag may complaint at ang complainant ay nagdala ng kanyang mga issue outside of DepEd, pero administrative complaint ang nature, ibabalik po yan under the DepEd. Okay? So, ibig sabihin nun, kung ganun yung premise, yung letter B and letter C ay may strike out na natin. No? Hindi na po pwede na dalhin ito sa barangay. Hindi din naman pwedeng i-file mo na lang ito ng right away under the police station. Otherwise, si police ay gagawa lang ng kanyang report pero ibabalik din kay DepEd yan dahil jurisdiction nga ay nasa regional director po ang ating disciplining authority. Right? Hindi rin mo pwede din i-activate ang grievance committee. Bakit? Kasi ang grievance committee ay para sa mga grievances lamang ng ating mga teachers, ng ating mga personnel sa iba't ibang mga kondisyon ng may patungkol sa trabaho. Kaya ang A ay i-strike out mo na rin yan. Kaya ang tamang sagot dyan ay letter D, forwarding the complaint to the regional director. Okay? Tingnan natin. Ayan. Question number 2 tayo. The following are the functions of the Child Protection Committee except. Okay? Ano, alin ba dito ang hindi kasama sa mga trabaho ng ating Child Protection Committee? Ang ating pong Child Protection Committee, mga kapitek, ay base sa ating DepEd Order number 40 series of 2012. Sa ibang mga videos po natin na inyong mapapanood along the way while you are reviewing, ito po ay bibigyan natin ng special na video. No? Lalagyan natin ng separate video para sa DepEd Order 40 series of 2012. Okay? So, alin po dyan ang hindi kasama sa mga trabaho ng Child Protection Committee? Marami pong trabaho ang Child Protection Committee. Una dyan, of course, is drafting ng School Child Protection Policy with a code of conduct and a plan to ensure child protection and safety, which shall be reviewed every 3 years. Specific po yan mga kapitek. Naka-specify po yan doon sa ating DepEd order. Initiate information dissemination programs and organize activities for the protection of children from abuse, exploitation, violence, discrimination, and bullying or peer abuse. That's also good. Kalagay din po yan sa ating DepEd order. And identify, refer, and if appropriate, report to the appropriate offices cases involving child abuse, exploitation, violence, discrimination, and other forms of abuse, no, na meron po tayo na nakikita natin or pwedeng mag-fall under the different categories based on the DepEd order number 40. So, ang A, B, and C mga kapitek ay kasama sa mga trabaho ng Child Protection Committee. Basically, kung ibabasahin po natin yung mga functions ng ating Child Protection Committee, nagiging ah, council committee po ito in order to prevent the cases to happen. Nakakapag-anticipate dapat ang Child Protection Committee ng mga programa na kung saan hindi na lalala or nagiging mababawasan yung mga kaso ng ating either the bullying or mga child abuse cases sa loob ng ating paaralan. Hindi po trabaho ng ating Child Protection Committee ang letter E, no? Conducting preliminary investigation on cases involving child abuse and bullying. Ah, ina-activate ang Child Protection Committee kapag may mga issues na kailangan na i-resolve but not to the point that they are allowed conduct yung preliminary investigation. Kasi pag sinabi po natin na preliminary investigation, mga kapitek, ay magfo-fall na yan under the rules of procedure po natin ng administrative complaint at ang kaya lamang bumuo ng grupo to conduct the preliminary investigation ay ang ating regional director. Okay? Kayang mag-forward ng mga details of the case via uh, the guidance office ng ating paaralan, which can be also, kaya nga nakalagay dito, no? Yung identify, refer, and if appropriate, no? Reporting the cases. So prior to the reporting of the cases, makapagkaroon muna ng mga identification of the basic facts. Parte yan ng trabaho ng Child Protection Committee. However, they are not going to do yung tinatawag na technical term na preliminary investigation. Okay? Check your understanding number 3 tayo. How can a prima facie case be determined? Ang prima facie case can be determined or ang prima facie, ibig sabihin dito ay mayroong probable cause. Parang yan, very technical yung term, no, ng mga kapite. Parang ang sinasabi natin na prima facie is that merong probability na na-commit yung administrative complaint na yun. So, paano ito madedetermine? Madedetermine ang prima facie case ano, kapag natapos na po ang preliminary investigation. So, after the conduct of the fact-finding or the preliminary investigation, doon na madedetermine na it's a prima facie case na tinatawag. Pag na-determine na yung ating prima facie case, doon na po gugulong yung formal investigation. Magkakaroon na po ng tinatawag natin na formal complaint, and then the formal complaint will be the one pagka na-determine na meron ng formal complaint na i-forward, ibig sabihin nito bubuuin na yung formal investigation committee, ano, yung magkakaroon na ng FIC na tinatawag po natin. Alright? So, ito lamang yung tatlong questions po natin para lang teaser so that you will be able to come up with a better direction kung saan ba tutungo itong ating discussion regarding BO number 49 series of 2006. So ito po ay panahon pa, no, ng ating kalihim, hindi ako ang nagkakamali, na si Jesly Lapus. Ayan. So dito sa ating presentation, we specifically presented yung ating DepEd order. Wala tayong binawas PDF. Kinonvert lang po natin ito. Maraming salamat kay I Love PDF, no? Para lang ma-convert natin ng ganito yung ating presentation. Okay. Una natin, ang section 1 po ng ating DepEd order on the revised rules of procedure of the Department of Education in administrative cases, i-highlight lang po natin yung tinatawag na, how do you call that? Tinatawag po natin na disciplining authority. Okay? Disciplining authority, makikita na po natin dito, the disciplining authorities in the DepEd shall be the number 1, the secretary, the regional director, ang ating the regional director of the specific region, and of course the division superintendent. Okay? Yan po ang ating ano. So we have here the disciplining authority. Uh, Tatlo po yan, Secretary of Education, the Regional Director, and the SDS. Okay? Yung ating mga disciplinary actions or administrative cases against officers and employees of the DepEd and of course, yung iba't ibang mga personnel na kaakibat dyan, ito po ay binibigyan ng ang naghi-hear ng mga cases, no, eh itong mga disciplining authorities lang po natin. Okay? The secretary shall have the original and exclusive jurisdiction. Linaw po yan, and the decisions of the Secretary of Education over administrative cases against the said presidential appointee shall be subject to the confirmation or the disapproval or the modification by the President of the Philippines. Sino ba naman ang tinatry niyan? Ito lamang itong mga third level officials. Yung DepEd Secretary na po ang gagawa or maghi-hear ng case. So usually itong mga yun yung sinasabi natin ng mga third level officials po natin yan. Okay? Pagka-division personnel naman, lang mga administrative assistant, all personnel ni DepEd na hindi naman po kasama sa teaching, ito po ang kanilang ang ating superintendent, ang kanilang disciplining authority. All teaching and teaching related personnel naman, ang kanilang DA or discipline authority ay ang regional director. Okay? So ano-ano yung mga grounds for the disciplinary action? Dishonesty, malagay po dyan. We have oppression, neglect of duty, misconduct, grave or simple misconduct, disgraceful and immoral conduct, being notoriously undesirable, okay? Discourtesy in the course of the official duties, and inefficiency and incompetence in the performance of duties. The receiving of personal use of a fee or a gift, binibigay po sa panunukol ba, no? So, hindi po pwede yan. Conviction of a crime involving moral turpitude. So, kahit na may mga conviction ng crime, hindi naman nagpo-fall under the moral turpitude, ibig sabihin na hindi naman po kasama yan, ano? Okay, mga civil cases, hindi po kasama. Improper or unauthorized solicitation of contributions, violation ng other civil service law, falsification of official documents, definitely. Lahat po ito, makikita naman po natin yan, habitual drunkenness, gambling, refusal to perform official duty, disgraceful and immoral or dishonest conduct, or prior to entering the service, physical or mental incapacity, borrowing money, lending money, willful failure to pay just debts due to the government, contracting loans of money or other property from persons with whom the office of the employee is concerned has business relations, so, pursuit of private business, vocation, or profession without the permission required by the civil service. The reason why kapag tayo ay halimbawa, may nire-require pa po sa atin, ang permit, no? Bago natin makapagawa ito, no? And in subordination. The main point of sharing all of this or highlighting all of this is so that kayo na mga nagpe-prepare for the exam ay mabigyan ng perspective na alin nga ba yung iba't ibang mga acts na po pwedeng mag-fall under administrative complaint. Marami po kasi yan. Engaging directly or indirectly in partisan political activities by one holding a non-political office. Ayan, hindi po din natin pinapayagan. Hindi pinapayagan ng ating DepEd. Nepotism, sale of tickets, sexual harassment as defined under the CSC resolution. Iba naman yung kaso ni sexual harassment. Meron siyang particular law, no, that will be discussed properly, no, pagdating naman dun kasi that will be under, hindi lang po administrative kasi yun, no? It's a criminal crime, a criminal case. The grievance committee is not allowed to hear and decide administrative disciplinary cases. Pag sinabi kasi natin na grievance, ang grievance po ay yung grievances, mga hindi pagkakaunawaan, no, mga cases of ano ba yung mga misunderstandings, no, between a teacher and a teacher, or should we say a teacher and personnel and the management of the school, ganun. Problema sa loading, some issues on learning environment, mga ganyan. So, nilalagay po natin ito under the grievance. Okay? Alright? So, ano naman yung procedure na kailangan natin na sundan? The procedure in the commencement or the commencing of the administrative cases. The administrative proceedings may be commenced by yung tinatawag natin motu proprio, no? By the Secretary of Education, the RD, no? Or the superintendent. Pag sinabi natin kasi na motu proprio, ibig sabihin po nito is that even without the formal complaint or the complaint coming from one party, ay pwedeng mag-commence ang ating administrative case. Technically, dapat may complaint muna bago siya magkaroon ng investigasyon. No? But in the case of a motu proprio case, ibig sabihin mayroong glaring na violation. No? Kitang-kita or very blatant yung violation na ginagawa. So kahit na walang complainant, pwedeng mag-commence yung kaso. Motu proprio ang tawag natin doon. Okay? Ah, kapag may complaint naman, meron siyang technical na mga composition under section number 4. The form of complaint includes the complaint shall be under oath and shall be written in a clear, simple, and concise language so as to inform the person complained of about the nature and cause of the accusation against him to enable him to intelligently prepare his defense or the answer. So ano ba yung mga content, no, na makikita natin diyan? The full name and address of the complainant, dapat nakalagay yan. Full name and address of the person complained as well as the position and office in the Department of Education. Dito po siya magfo-fall. Kikita natin po itong mga contents po ng ating complaint. Okay? Enumeration of the relevant material or facts which show the act or omission was allegedly committed, and certified true copies of the documentary evidences and affidavits if needed, and the certification of the statement of non-forum shopping. Ano bang ibig sabihin ng non-forum shopping? Pag sinabi po natin na non-forum shopping, ibig sabihin yung jurisdiction-wise, sinusunod po natin. Hindi po tayo nagpa-file ng kung saan-saan. Okay, kung nag-file ka na kay DepEd na lang. Ang iba kasi, syempre, pinafile sa civil service, nagpa-file pa sa PRC. May mga other agencies pa kung saan ito ipina-file. So, tawag na natin doon ay forum shopping. Hindi na, parang the intention is no longer to settle the case but to paint a negative allegation na lang doon sa person. Okay. Section number 6, when and where to file the complaint. No? So, kanino ba dapat ipina-file? Importante ito dahil bilang school head, alam natin, no, na kapag may dumating na complainant sa atin, alam natin kung paano siya ititreat. When and where. Sworn written administrative complaints may be filed at any time with the school superintendents concerned for cases against the non-teaching. Okay, and with the regional director naman in the case of teachers and against their personnel at their respective regional office. At the legal division of the central office for cases against the presidential appointees and employees at the central office. Ulitin na naman po natin ang ating mga presidential appointees. Sila po yung ating mga third level officials. Okay, mga third level officials. Sino ba yung mga third level officials natin? Ang ating assistant superintendent, ang ating superintendent, assistant regional director, and the regional director. Even our hepe, mga chiefs of the division like the CID chief, the SGOD chief, for example, they're still under the second level position and they're appointed by the superintendent. So technically, they are not a third level position and they are not presidential appointees. Okay. What will happen during the withdrawal of the complaint? Halimbawa, nakapag-file na ng complaint, balikan natin yung section 6. Dumating sa school, nagko-complain. Okay, kagaya ng nilagay natin dun sa tanong, nagko-complain. Anong gagawin natin? Ifo-forward po natin sa ating proper authority. Pino-forward po yan sa ating regional director for that matter for proper hearing. Right? Pwede din naman na yung complainant lang mag-direct sa ating ano, hindi na dumaan sa'yo. Paano kung hindi dumaan sa'yo yung hindi dumaan sa school yung complaint? That's okay, no? Hindi mo naman hawak yun kasi nakalagay naman sa ating section 6 na pwede naman nilang dalhin sa regional director yung kanilang mga complaint. Pag nag-withdraw ng complaint or withdrawal, no, the withdrawal of the complaint does not result in its outright dismissal nor in the discharge of the person complained of any of from any administrative liability. Sinasabi lang dito na kapag nakapag-file na po ng complaint ay hindi basta-basta na madadrop yung case. Right? When there is obvious truth or merit to the allegation in the complaint or where there is documentary evidence that would tend to prove the guilt of the person, the same should be given due course. So, tutuloy at tutuloy pa rin yung kaso na yan. Alright? Section 8. Actions on the complaint. So the DA, pag dumating na yung complaint sa kanya, the DA concerned shall dismiss outright a complaint in its face if there is obviously no truth or merit to the allegations therein. Okay? Kayang gawin yun ng disciplining authority. Kung para sa kanyang appraisal ay walang merit yung case na yon, then it will be dismissed outright. Okay? It will be under the appraisal and the wisdom of the disciplining authority. The DA shall also dismiss the complaint if there is same in accordance with the required form, no, and if it does not comply with the required content of the complaint. So technical ano yan, madidismiss yan kapag may technicality sa content. No? If the complaint is sufficient in form and substance, the disciplining authority shall give due course to the complaint by appointing within 10 days from receipt of the complaint and investigators who shall conduct yung fact-finding investigation or yung tinatawag po natin na preliminary investigation. Okay? So kung nakita na may basihan, then mag-conduct ng preliminary investigation. Sinong gagawa nito? Gagawa niyan ay yung mga investigators that will be appointed by the disciplining authority. No action shall be taken on anonymous complaint unless the disciplining authority decides to adopt the same and make it and file it as a motu proprio. Okay? Kapag ang complaint ay anonymous, hindi yan binibigyan ng action ng ating disciplining authority unless nakikita niya na talagang may merit. Kapag may merit at kahit na anonymous yung complaint, it will not go through the process of there's someone filing a complaint. No, motu proprio na kaagad ito. Okay? Under the jurisdiction na ito or under the appraisal ng ating disciplining authority. Okay. So, may complaint, dumating kay disciplining authority, nalaman or na-appraise ng disciplining authority na may possibility na in yung content ay okay. Ano susunod? Magkakandak na ngayon ng preliminary investigation. So, section number 9 will detail kung ano yung mangyayari or ano mga important points in the conduct of the fact-finding investigation or tinatawag natin na preliminary investigation. So within 5 days from the receipt of the appointment of an officer of the DepEd as investigator issued by the disciplining authority, the designated investigator shall commence, dito po tayo, shall commence the fact-finding investigation by issuing an order requiring the person complained to submit within 3 days from receipt of the said order together with the copy of the complaint and the supporting documents thereof. Counter affidavit naman para doon sa mga person complained of to submit the counter affidavit and shall be considered as a waiver thereof kapag hindi siya nag-file ng kanyang answer. Pag walang answer at walang counter affidavit, ibig sabihin wini-waive na niya yung part na yun. So the case will be tried based on available documents. Upon receipt of the counter affidavit, the investigators may summon the parties to a conference where the investigators may propound clarificatory questions. The investigators may also interview any possible witnesses. Trabaho po yan ng ating mga preliminary investigators. Okay, during any hearing conducted for clarificatory questions, the investigators shall maintain the minutes of the proceedings, which shall include the clarificatory questions propounded to the parties and their witnesses, and the answers given thereto. No? So, part yan ang kanilang documentation. After the termination of the hearings for clarificatory questions, the investigators shall make an ex parte examination of the records and the documents submitted by the complainant and the person complained of. A fact-finding investigation or preliminary investigation shall commence not later than 5 days from the receipt of the investigators of the order of the disciplining authority appointing them to be part of the investigating team and shall be terminated within 30 days thereafter. So meron siyang data on the dates na kailangan po natin na sundin. Okay? Anyway, that will be upon the wisdom of the regional or the disciplining authority kung sino yung bibigyan niya ng power to investigate. Okay? The investigation report within 5 days from the termination of the preliminary investigation shall be submitted in complete records of the case to the disciplining authority together with the investigation report, which should contain the findings and the recommendations. Mahalaga ang investigation report kasi dito magbabase yung tinatawag natin na prima facie case. The prima facie case is established during the investigation. Formal charge shall be issued by the disciplining authority. A prima facie case shall mean that there is reasonable ground to believe that the respondent is probably guilty of the charges against him. Alright? So, nakikita po natin yung flow, So, mula doon sa filing ng complaint, dumating sa opisina ng disciplining authority. Si disciplining authority ang nagbigay ng order para sa pagbuo ng preliminary investigating team. Pagkatapos noon, ang mga preliminary investigators ay magsasabit ng kanilang investigation report. Doon sa investigation report, doon ma-establish kung may prima facie case. Kapag may prima facie case, or may probability na guilty nga yung kinukomplain, doon na mag-umpisa ang Section 10. Ang tawag natin dito ay formal charge. The formal charge now shall contain a specification of the charges, a brief statement of material, relevant facts accompanied by the certified true copies of the documents or documentary evidences. Okay? So meron ding timeline yan, 72 hours from the receipt thereof, an advice for the respondent to indicate his answer whether or not he elects a formal investigation of the charge and a notice that he is entitled to be assisted by a counsel of his choice. Okay? So, bibigyan na ng notice yan kasi may formal charge na. Kapag doon naman sa investigation report ay wala namang na-find out na probability at hindi na-establish yung prima facie case, then it is within the bound of the disciplining authority to terminate or to dismiss the case on that ground. Okay? Nasa wisdom po nila. Submission of additional evidence. If the respondent had already submitted the comment under oath or counter affidavit during the fact-finding, he shall be given the opportunity to submit additional evidence. So Section 11 will allow that. Meron tayong prohibited pleadings. The disciplining authority shall not entertain dilatory requests for clarification, bills of particular, or motions to suspend proceedings on account of a pending court case in the absence of a temporary restraining order or injunctive writ. If any of these pleadings are interposed by respondent, the same shall be considered as an answer and shall be evaluated as such. Ibig sabihin, merong separate po na pagdinig yung ating administrative case over the other court cases ng criminal in nature. Section 13, the answer. So the answer is shall be in writing and under oath coming from the respondent. and shall contain material facts and applicable laws, if any, including the documentary evidences supporting yung kanyang defense. Alright? So, what if hindi nakapag-file ng answer? No, if the respondent fails or refuse, kung hindi nakapag-file ng answer, if the respondent fails or refuse to file his or her answer to the formal charge within the 5 days receipt thereof, yung ibig sabihin nun? Yung ibig sabihin nun, it shall be considered as a waiver to the right, no? And magkakaroon na ng commence ng formal investigation. So whether or not nakapag-file ng answer yung ating respondent or yung person na kino-complain, ang ibig sabihin nito ay tuloy-tuloy pa rin yung formal investigation. Ibig sabihin nito ay i-continue yung kaso and uh, yung mga documentary evidences will be evaluated without the answer of the respondent. Okay? Section 15, ito yung ating term on the preventive suspension. Pag-suspend dun sa person, if upon motion of the complainant or the motu proprio case, the proper DA may issue an order of preventive suspension upon the issuance of the formal charge immediately thereafter to any subordinate for the reason na for the following charges: dishonesty, oppression, grave misconduct, neglect in the performance of duty, or if there are reasons to believe that the respondent is guilty of charges which would warrant his removal from the office. Okay? So ito po yung ating mga kaso. Kapag ito yung mga kaso, ibig sabihin nito, pwedeng patawan ng preventive suspension. Ang Section 16 naman ay mga reasons, no, sa pagpataw ng ating preventive suspension. An order of preventive suspension may also be issued by the DA to temporarily remove the respondent from the scene of his misfeasance, ito yun, or malfeasance, and to preclude the possibility of exerting undue influence or pressure on the witnesses against him or tampering of documentary evidences on file with his office. Lalo na kapag medyo nasa posisyon yung kino-complain, meron daw possibility na ma-influence yung mga witnesses, ma-intimidation, makapag-tamper ng mga documentary evidences. So, nagkakaroon ng preventive suspension for that matter. Okay? Ang Section 17 ay the substitute for the preventive suspension. In lieu of the preventive suspension for the same purpose, the proper DA or head of the office may reassign respondent to other units of the agency during the formal hearings. Okay? Ang Section 18 naman, duration ng ating preventive suspension. Ilan ito? When the administrative case against an officer under the preventive suspension is not finally decided, within the period of 90 days after the date of the preventive suspension, unless otherwise provided by special law, he shall automatically reinstated in the service, provided that when the delay in the disposition of the case is due to the fault or negligence or petition of the respondent, should not be included in the counting of the calendar days. So, malinaw naman yung sinasabi na 90 days yung preventive suspension. Kapag hindi na-decide yung case within that time frame, ibig sabihin, automatically reinstated yung personnel. Okay? Pagka ayun, may 90 day suspension, pag hindi na try yung case na yon within that day, within that period, then reinstated automatically. Okay, next. Remedies from the order of the preventive suspension. The respondent may file a motion for reconsideration. Okay, pwedeng ganon. Pero may mga conditions yan. May mga conditions for the remedies on the preventive suspension. And then, the respondent does not request a formal investigation. One shall nevertheless be conducted. Kasi formal investigation na yan. Ang formal investigation ay magko-commence kapag na-file na yung formal complaint at na-form na ni DA yung kanyang formal investigation committee na makikita natin sa section number 21. The creation of the formal investigation committee within 5 days from the receipt of the respondent's answer. The DA shall issue an order creating the formal investigating committee, which shall be composed of the following. When the respondent is a teacher, under Section 2 of the RA number 4670 or the Magna Carta for Public School Teachers, ito yung ating composition of the FIC. The school division superintendent or the duly authorized representative, pwede yung ASDS or anybody who will be appointed by the superintendent, must have at least the rank of a division supervisor where the teacher belongs as the chairman. Okay? So kung hindi man si ASDS ang i-appoint o yung mga hepe yung i-appoint, basta division supervisor yung kanyang position. A representative of the local or in its absence any existing provincial or national teachers organization. Okay, kung pwedeng ilagay. The supervisor of the division at the last two to be designated by the disciplining authority. Okay? So ito yung mga FIC po natin. When the respondent is the ASDS, Assistant School Superintendent, o yung mga third level position, the secretary will be the chairman, and the duly authorized representative of the Philippine Public School Teachers Association naman as a member. Alright? So yun lang, yung mga gusto natin na-emphasize yan pagdating sa FIC. So, bubuuin yung formal investigation committee via the order coming from the disciplining authority. May mga provisions yan under the Republic Act 4670. The commencement and duration of the formal investigation. Tingnan natin. Right. So, the duration of the formal investigation shall be held not earlier than 5 days, not later than 10 days, from the receipt of the order of the disciplining authority constituting the formal investigating committee. Okay, yan po yan. 5 to 10 days lang ang ibinibigay under section number 22. Okay? Magkakaroon ng pre-hearing conference. The commencement of the formal investigation, the hearing officer shall conduct a pre-hearing conference for the parties to appear. Consider and agree on any of the following. Una, submission of the case for resolution based on position papers, memoranda of the parties without any need for further hearings. Pwedeng ganun. Stipulation of facts, simplification of issues, waiver of objections to admissibility of evidence, limiting the number of witnesses and their names, dates and subsequent hearings, and such other matters that may aid in the prompt and just resolution of the case. So makikita natin, meron po kasi tayong tinatawag na quasi-judicial, or whatever you call it. Yun, dito papasok ito. No? So yung mga kaso ng ganyan, hindi na natin pinapadaan sa mga judicial proceedings, but tinatawag na natin na quasi or quasi-judicial. Ito yun. Sa DepEd, meron tayong quasi-judicial process. At ito yung sinusundan natin via the DepEd Order number 49 series of 2006. So para din siya talagang hearing, pero sabi nga naman dito, pwede naman na mag-submit lang ng mga case for resolution based on the position papers. So yung position paper na lang ang pagpapasayahan without any need for further hearings. Pwedeng ganun. Pero nasa pa rin yan, nasa wisdom pa rin yan ng chairman ng investigation committee. Okay, kung paano niya ikakandak yung mga hearing conferences. Usually, naaatasan yan is the superintendent. Siyempre, it's the superintendent. Pero kung ayaw naman ni superintendent, pwede niyang i-assign yung kanyang representative via the assistant superintendent or the division supervisors. All right. So, appearance of parties, it shall be the duty of the parties and their counsels if any to appear at the pre-hearing conference. The non-appearance of a party may be excused only if a valid cause is shown therefore. Effect of failure to appear during the pre-hearing conference. Failure of both parties to appear at the scheduled pre-hearing conference is not necessarily a cause for the dismissal of the case. Ayan. So, malinaw po yan. Kapag hindi umattend, walang bearing pa rin. A party who appears may be allowed to present his evidence in the absence of the adverse party whom was duly notified of the pre-hearing conference. However, if the absent party is able to show that there is a valid cause for his absence, he shall be afforded the opportunity to cross-examine the witnesses presented during his absence. Okay? Kapag valid. Kapag hindi naman valid, according to the appraisal ng committee, wala din yan. Record of the pre-hearing conference shall be recorded, and upon termination thereof, the formal investigation committee shall issue an order which shall recite in detail the matters taken up in the conference. Okay, so hindi na masyadong ng mga technical, non-litigious in nature and formal investigation procedure. Ito yung emphasis natin. The conduct of the FI or the formal investigation shall be non-litigious in nature, subject to the requirements of the due proceedings. In administrative cases, the technicalities of law, procedure, and evidence shall not strictly apply thereto. O, kumbaga parang trial yung dating, no? Hindi naman po. The formal investigating committee may avail itself of all reasonable means to ascertain speedily the facts of the case. The committee shall take full control of the proceedings with proper regard to the right of the parties to due process, and shall limit the presentation of evidence to matters relevant to the issues before the committee, necessary for a just and speedy disposition of the case. Non-litigious in nature, dinedefine lang nito na hindi ito parang trial in the mga criminal courts natin na tinatawag. Tandaan natin, quasi-judicial po ang procedure or ang nature po ng ating committee. Continuous hearing until termination or postponement. The formal investigation committee shall set the case for continuous trial on the date set by the committee as agreed upon by the pre-hearing conference. Again, so hanggat hindi na ipipresent lahat ng facts, hindi natatapos yung, gano'n lang ibig sabihin, hindi natatapos yung investigation. Although merong timeline na sinusunod, nabanggit natin na within 30 days ang ibinibigay na timeline. A party who was duly notified of the hearing. However, if the absent party is able to show that there is a valid cause for his absence, she shall be afforded the opportunity to submit written interrogatories to be answered by the witnesses. And dito po tayo. Presented during his absence. In case of two successive unjustified non-appearances of any party in the proceedings, it shall be the option of the party who is present to submit the case for resolution on the basis of the records of the case and the evidence so far presented. Siyempre, may timeline ding sinusunod dyan. Nagiging stricto lang yan dahil baka ma-technical din yung ating formal investigation committee for that matter. Next is the adequate time to prepare defense. In scheduling the hearings, the committee shall ensure that the respondent be given adequate time for the preparation of his defense. Section 30 is the affidavit of witnesses. Only affidavits shall have been identified by the affiant should be considered as evidences. The affidavit of any witness shall constitute his direct testimony subject to the written interrogatories. Okay? Merong preliminary matters. This will be very basic para sa ating mga formal investigation committee. At the start of the formal investigating committee or at the start of the hearing, shall call the case, ask for the appearances of the parties, and shall proceed with the reception of evidence for the complainant. Okay? If the respondent appears without the aid of a counsel, he shall be deemed to have waived his rights thereto. So, pwede. Pwedeng magdala. Pwedeng magdala. Okay? Pwede ring hindi. Before taking the testimony of a witness, the hearing officer shall place him under oath and then takes his name, address, civil status, age, and the place of employment. Ang Section 32, in-specify nito yung appearance of counsel. Any counsel appearing before any hearing or investigation shall manifest orally or in writing his appearance as prosecutor of the case, counsel for private complainant, or counsel for the respondent, stating his full name, IBP receipt, and exact address where he can be served with notices and other pleadings. Any pleading of appearance of counsel without complying with the above stated requirements shall not be recognized. However, the parties may choose to represent themselves without the assistance of a counsel. So, optional yun. Pwedeng meron, pwedeng wala, na mga abogado na kasama. Okay? Order of the hearing, sige, hindi naman siguro na ito masyadong bibigyan ano, we were just being reminded, no, yung proseso. So yun ay trabaho pa rin ng ating formal investigation. Yan, may mga objections, um, written interrogatories in lieu of the cross-examination. Upon the termination of the direct examination, the adverse party shall answer the written interrogatories. So ganun yan. After the conclusion of the testimony of the witnesses, the prosecution or the private complainants to present yung succeeding witnesses and so on. Until such time na matatapos yung presentation lahat ng mga evidences. Okay? Section 34 will give the provisions for the objections. Meron ding Section 35 ng markings, yung pag-mark ng mga documentary evidences. Exhibiting shall be properly marked by letters if presented by the prosecution or private complainant, and by the numbers naman is presented by the respondent. Okay? Letters for the complainant, and numbers naman para sa ating mga respondent. Okay? Under malinaw naman po yun. Issuance of subpoena, the committee shall issue or may issue subpoena ad testificandum to compel the attendance of witnesses, and yung ating subpoena for duces tecum naman for the production of the documents for things. Alright, meron pa ba tayong pwedeng i-specify dito? Records of the proceedings for Section 37, filing of the motions, petitions, and appeal. Any motion or petition, appeal, and other proceedings sent by registered mail shall be deemed filed on the date shown by the postmark. Yan ang tinitignan natin. So, hindi yung one envelope shall be attached to the records of the case in case of personal delivery. The date stamped therein by the office concerned. Okay. Section 39, effect of the pendency of the administrative case. Pendency of the administrative case shall not disqualify respondent for promotion or from claiming maternity or paternity benefits. Kahit na may administrative case na pending, hindi ito nagiging balakid para ma-promote yung personnel or whatever. Okay? So, hindi ito balakid para doon. And of course, yung claiming ng other paternity or paternity benefits. No publicity during the pendency of the administration. No publicity shall be given to any administrative case against a teacher during the pendency of the case. Tama din naman. Hindi ito pinapublicize. So right after, within 15 days after the conclusion of the investigation, the formal investigation committee with the disciplining authority shall be able to submit yung tinatawag natin na formal investigation report or the report of the investigation. The complete record shall be systematically and chronologically arranged, paged, and securely bound to prevent loss. So the formal investigation report shall not be given to the parties and shall serve only as a guide to the disciplining authority who may or may not adopt the same entirely or partially. So, nagiging guide yung investigation report na yon para sa ating disciplining authority to render the decision. It may or may not. Siyempre, nakadepende sa report yan. Nakalagay naman may or may not. Pero, siyempre, technically, the disciplining authority will have to rely on the result of the investigation report. The disciplining authority shall render the decision on the case within 30 days from the receipt of the report of the investigation. Okay? So, yun na. Doon na siya matatapos. Kakapag-render ng decision. No? Magre-render ng decision yung ating disciplining authority once na na-receive na niya yung formal investigation report coming from the FIC within 30 days of the receipt thereof. Okay? Babalikan lang natin ng konti, mabilis lang. Nag-file ng complaint, nag-conduct ng na-determine yung prima facie case via the preliminary investigation. Pag may prima facie case, magkakaroon ng formal investigation. Bubuin yung formal investigation committee. And then after that, gagawa ng formal investigation report. The formal investigation report will now be forwarded to the disciplining authority for the rendering of the decision. Okay? The decision of the Secretary of Education in Administrative Cases, okay, over yung mga presidential appointees shall be subject to the confirmation, modification, and disapproval by the President. The final order or resolution of the President confirming, modifying, or disapproving the decision against the presidential appointee shall be subject to motion for reconsideration. Ganun din. Meron din siyang mga remedies kapag una nang nakapag-file or meron ng ibinigay na resolution. Okay? The decision of the Secretary of Education against non-presidential appointees, okay, whereby a penalty of suspension for more than 30 days or a fine not exceeding 30 days shall be final and executory. If the penalty imposed is suspension exceeding 30 days or fine in the amount preceding or exceeding 30 days salary, the same shall be final and executory after the lapse of the reglementary period for the filing of the motion for reconsideration. Okay. Tingnan natin. So, dapat kung more than 30 days, within the approval ni Secretary, no, nakalagay. But if it is within 30 days lang, at kapag walang na-file na motion for reconsideration, ibig sabihin nito, mag-take effect na yung decision. The decision of the regional director where penalty is removal, no, shall be subject to the confirmation or modification by the Secretary of Education. Decision as confirmed, modified, or disapproved shall be subject to a motion for reconsideration of the Secretary of Education or to an appeal to the Civil Service Commission. Pwede naman yan. Decision of the RD where penalty is suspension or fine, a decision rendered by the RD whereby a penalty of the suspension for not more than 30 days or a fine in the amount of 30 days salary is imposed shall be final and executory. However, if the penalty imposes suspension exceeding 30 days or more than that, then it should be how do you that? In the amount of exceeding 30 days salary, the same shall be final and executory after the lapse of the reglementary period for the filing of the motion for reconsideration. Pwede na mag-file ng motion for reconsideration, depende sa grounds available kapag may mga bagong ebidensya na. So ito yung mga grounds po natin. Please take note of this, mga kapitek. No new evidence has been discovered. The decision is not supported by the evidence on record, and there are errors of law or irregularities. Ang errors of law or irregularities have been committed po pwedeng yung mga timelines hindi na-follow, pwedeng gamitin yun na reason for the motion for reconsideration. Okay? New evidence has been discovered that would materially affect the decision and po pwede pong i-file yung reconsideration. Other than that, maglalapse yung reglementary period and magiging final and executory yung ating mga decisions. Alright? So, ano pa ba yung mga importante dito na kailangan po natin na tignan? So, you have to take note of this, yung ating mga classification of the different offenses. Although this will be under the ground, it will be under the perusal ng ating disciplining authority. Pero just to give you the background there na ito yung mga possibility. These are the following grave offenses with corresponding penalties. So, first offense, dismissal, kagaya ng dishonesty, gross neglect of duty, grave misconduct, being notoriously undesirable, conviction of a crime involving moral turpitude, falsification of official document. Lahat ng ito, nepotism, disloyalty, oppression, pwedeng magkaroon ng outright yan na mga even during the first offense. Okay? Even during the first offense. Nabanggit na po natin ito kanina and you were already given some points, no? When it comes, no? Sa review naman, hindi naman na yan hinahanap, no? Hindi naman yan tinatanong in detail. Pero ang gusto lang natin na makita dito is that there are a lot of possibilities na pwedeng ang isang personnel ay magkaroon ng administrative complaint. Bilang school principal or aspiring principal, dapat alam mo yung mga technicalities na yan. so that whenever there will be a complaint that will be forwarded to your office for that matter, alam mo kung paano iti-treat yung case na yun. Importante yan. So, binibigyan tayo ng idea. Sir, hindi naman ako abogado para malaman yun. Yes, quasi-judicial nga yung process natin. Hindi natin kailangan ng mga counsel for that matter. No? So, pero kailangan yung mga proceedings na yan, dahil nandito ka tayo sa DepEd, alam natin. No? There should be a working knowledge, no, of the procedure on how we will be approaching yung ating mga iba't ibang administrative cases. Alright? So far, yun lang yung i-specify po natin, no? Kasi mga technicalities na po itong mga sumusunod na mga part. As mentioned, this DepEd order was signed noong 2006 pa in the time of our Secretary Jeslie A. Lapus. Maaari niyong matanong kung may mga other points ba na kailangan mong i-consider. Yes, you have to take note na meron din po tayo mga civil service rules, pero ultimately, itong DepEd order naman na to ay nakabase sa existing na ating mga civil service rulings. Alright? So, yun lang po para po sa ating video sa ngayon. Maraming salamat po muli, mga kapitek, sa inyong panonood. And sana ay meron po tayong na-share, no, na mga tidbits para po sa inyo. Kung meron kayong mga comments, ay pwede po kayong mag-leave ng comment sa ating comment section. And kung meron po kayong isa-suggest sa mga videos na gusto nyo marinig or ma-discuss, then you can comment down below. Maraming salamat. Please like, please share, and please subscribe for more videos. Thank you and magandang araw.